Welcome to EUPrivacyForAll Session53 on GDPR, Article 89 Archiving. Article 89 on the safeguards and derogations relating to processing for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes, lays down that those kind of processing shall be subject to appropriate safeguards in accordance with the regulation in order to protect the rights and freedoms of data subjects. Those safeguards will ensure that technical and organizational measures are taken, in particular to ensure the respect of the principle of data minimization. That includes pseudonymization, provided that those purposes can be fulfilled in that manner. Where those purposes can be fulfilled by further processing of data which does not permit or no longer permits the identification of data subjects, those purposes shall be fulfilled in that manner. Where personal data are processed for scientific, historical, or statistical purposes, Union or Member State law may provide for derogations from certain data subjects' rights, subject to the condition and safeguards referred to in the first paragraph, insofar as such rights are likely to render impossible or seriously impair the achievement of the specific purposes of the processing, and such derogations are strictly necessary for the fulfillment of these purposes. Where personal data are processed for archiving purposes in the public interest, Union or Member State law may also provide for derogations from those rights to the conditions and safeguards referred once again in paragraph 1. Where processing referred in those paragraphs serves at the same time another purpose, the derogations shall apply only to the processing for the purposes referred to in those paragraphs, that is to say, scientific, historical, statistical, or public interest. Residual 156 lays down that those appropriate safeguards include the fact that, in particular, the principle of data minimization would be met. That is to say that the controller will have the obligation to assess the feasibility to fulfill the purposes in mind by processing data which does not permit or no longer permits the identification of data subjects. The recital also mentions all the set of rights impacted by such provisions, that is to say, the right to information, rectification, erasure, to be forgotten, to restriction of processing, to data portability, and to object. It specifies that such national provisions may entail specific procedures for data subjects to exercise his or her rights. In Recital 158, it is enhanced that the regulation should not apply to deceased persons. Member States should also be authorized to provide for the further processing of personal data for archiving purposes, for example, with a view to providing specific information related to the political behavior. In Recital 50, it is clarified that the further processing of data for archiving purposes in the public interest, scientific, historical, or statistical purposes should be considered as such as compatible lawful processing operations. In Article 5.1 on the principles related to personal data processing, it is laid down that personal data shall be collected for specified explicit and legitimate purposes and not further processed in a manner that is incompatible with those initial purposes. Further processing for public interest, scientific, historical, or statistical purposes is not to be considered as incompatible. Data should also be kept in a form which permits identification of data subjects for no longer than is necessary, and it may be stored for longer period, insofar as the personal data will be processed solely for archiving purposes, once again, in the public interest, scientific, historical, or statistical purposes. Directive 95/46 lays down in Article 6.1 that the principles related to data quality entail that Member States shall provide that personal data should be collected for specified explicit and legitimate purposes, but also that historical, statistical, or scientific purposes shall not be considered as incompatible. Member States shall lay down appropriate safeguards for personal data stored for longer periods for historical, statistical, or scientific use. What should accountable data controllers and processors get prepared for? They should consider that whenever public interest, statistical, historical, or scientific purposes are at stake, they should involve technical and organizational measures to respect the principle of data minimization and mitigate privacy risks, notably using pseudonymization. They should consider that such processing of data should not, as far as possible, permit the identification of data subjects. However, national derogations could be decided upon. Regarding scientific and historical research purposes or statistical purposes, Member States could provide derogations to the right of access, to rectification, to restriction, and to the right to object. Regarding public interest purposes, Member States could provide derogations to the right of access, rectification, restriction, the right to object, but also the obligation to notify recipients and to data portability. In both cases, derogations to those rights should be likely to render impossible or seriously impair the achievement of the specific purposes of public interest, and such derogations are necessary for the fulfillment of these purposes. The regulation, finally, does not apply to deceased persons. The question triggered now regards the requirements on de-identification of data.